So, Mr. Jones, and this is the point of final decision. If you were to plead guilty, there would not be any further proceedings, and you could discuss with the state whether you want to enter a guilty plea. If you don't enter a guilty plea, then I have to go ahead with a trial on the case, and unless you waive a jury trial, you will have a jury trial, and we will bring up a jury this morning, and we will try your case. So are you going to plead guilty or not guilty?
Well, sir, I've been trying to make a informed and voluntary plea of guilty since arraignment. I've not been able to do so.
A plea would be informed because you know the charges against you, and you know what your rights are. You have not gotten an attorney. You've been advised of that right already. You have not applied for the public defender. And so I guess we will be doing a jury trial unless you say something different.
Well, sorry, go ahead.
All right.
No, I didn't mean to cut you off. Go ahead and finish what you were saying.
Yeah, we're going to proceed and bring up a jury and select a jury and proceed with the trial.
Well, I mean, like I said, I have every intention on making a voluntary and...
No, this is the time. You either plead guilty or you ask to plead no contest, or we have a trial. You run out of time.
Does this court not accept voluntary pleas of guilty?
If you're pleading voluntarily, you can go ahead and plead voluntarily, and if you're not pleading voluntarily, then we have to have trial.
I have a couple clarifications I need cleared up before I'm able to do so.
What are the clarifications you want?
First, do I have the right to a fair and meaningful hearing here today?
You have a right to a fair trial, and you will get one unless you plead guilty and waive that right.
So was that a yes or a no, sir?
I've told you what will happen. I have answered your question. Do you have any other questions?
I'm still not clear on the first
A guilty
clarification.
plea waives any right to a further hearing. Without a guilty plea, we will go ahead to trial. It's that simple.
So I do have the right to a fair and meaningful hearing here today?
You have a right to a trial, which is a fair and meaningful hearing. All right, let's wait on.
Sir,
if you want to be excused, but you're close enough that, on 2 hours call you come back, then if somehow this trial doesn't happen, we'll bring you in at 1, and otherwise, we'll see you in the morning.
Okay, so be here at 9 no matter what.
Yeah.
I might be called back on 2-hour call.
Unless you want to wait around and see if we get started picking a jury. Yeah.
I'll probably wait about 10 more minutes.
All right. So let me know when we're ready with the plea.
Mr. Jones, my offer to you today will be a fine of $250 plus court costs. Plead guilty to the case, and I'll close it out. Do you want to accept that offer?
Have you filed a proper case?
Sam, I have one question. Do you want to accept the offer or not?
Am I not allowed to get my questions answered?
That's for the judge. I don't answer questions. So do you want to plead guilty or not?
You don't answer. So you haven't filed a proper case.
Okay, that's okay. Thank you.
All right, Ms. Jones, I take it you don't affirmatively want to waive the jury trial.
Like I stated before, I would like to plead guilty. That's been my intention from arraignment. I'm not even ready for trial. I've been trying to plead guilty. I haven't even had a chance to file motions or to retain counsel.
You have,
But
hold on, Ms. You have had months to hire counsel. I have advised you of your right to be represented by an attorney. I asked you if you wanted to apply with the public defender, and you kept just saying you wanted answers to these questions. I answered those questions.
Sir,
You are not entitled to any sort of hearing except when you're not in custody prior to trial, except under very limited circumstances. Those circumstances include if you have an affirmative defense that involves immunity, such as self-defense. This arises out of a traffic accident. So even if you file a motion for the affirmative defense, it would be frivolous. Or you file a constitutional motion such as for an illegal search. I'm not aware of any search. Nobody's told me about any search, and you haven't filed a motion. You're required to file motions at the time of arraignment. You had an opportunity to have the arraignment continued once if you wanted time to hire an attorney. You didn't hire an attorney. You didn't ask to speak to the public defender. Your time for filing motions is passed.
I intended to plead guilty. So why would I?
Because you never pled guilty.
But my clarifications were never.
There would be no hearings prior to trial.
My clarifications were never cleared up for me. I was not fully informed.
Well, the court differs from you on that. So we're ready to go trial.
So are you telling me that just besides those few circumstances, those are the only ways that I would be entitled to a fair and meaningful hearing?
Prior to trial, you get one in the trial, we're ready to go.
But under those circumstances, would that be the only time that I would be entitled to a fair and meaningful hearing? But pre-trial.
I've listed every possible thing, but none of them apply in this case. I've told you that before.
Well, those circumstances.
Go ahead with the trial now.
Those circumstances and every other
Plead guilty
circumstance.
now.
I'm sorry?
Unless you want to plead guilty now, we're going to go ahead with the trial.
I have a few more clarifications. Do I have the right to be informed of the cause and nature of the charges and proceedings against me here today?
I have read you the charges against you before. I can read them to you again.
My clarification was, do I have the right to be informed of the cause and nature?
Yes, and you have been.
Okay. Am I presumed innocent of these charges here today?
What?
Am I presumed innocent of these charges here
Yes,
today?
you are presumed innocent.
Am I presumed innocent of every element of these charges here today?
Yes.
Is jurisdiction an element?
What?
Is jurisdiction an element?
Yes.
Am I presumed innocent of jurisdiction?
No.
So I'm not.
Jurisdiction
So-
is subject matter jurisdiction for the court. That is a decision of the court. It is appealed within the court system, the issue of jurisdiction.
So I'm not presumed innocent of the charges. Is that what you're saying?
Presumed innocent of charges.
How can I be presumed innocent of?
Every factual element of the charge.
How can I be presumed innocent of the charge if I'm not presumed innocent of every element of the charge?
It's not an element of the charge. Do you want to go? I'm getting tired of answering questions. Do you have any more questions? I'll answer a couple more, but then we'll go ahead with the trial once you plead guilty.
So you just stated that jurisdiction was an element of the charge and now it's not?
All right, let's bring up the jury.
Okay, go on.
Objection, Your Honor.
Your objection is noted.
Do you represent a party in this case?
No.
So is this your own private court?
No, it's a court of the state of Georgia.
So you represent the state of Georgia?
I'm not going to.
Okay, sir, that's enough until the jury.
I'm going to instruct you on how the trial is going to proceed, Mr. Jones. We're going to bring up a jury panel, and you will have the opportunity, when it's your turn, if you wish, to ask questions to the entire panel that can be answered yes or no by raising their number. After we do those general questions, we will ask each member of the panel, until we have qualified 12 potential jurors, to stand up and tell us who they are and what they do, and you can ask individual questions of jurors. When we complete the questioning of the panel, strike up to 3 jurors. And what will happen is a list of the jurors will be put in front of the state first, and they will either strike or accept the juror. And then it will be put in front of you, and you will either strike or accept that juror. You start with juror 1, and then you go through that process until we have 6. Since each side only has 3 strikes, when we get through 12, we will have a jury panel. Now, prior to actually doing the strike, you can move to strike a juror for cause, and you can say what the bias is that you think the juror has manifested, and the court will rule on whether the strike for cause will exist or not. After we finish selecting the jury, you will have the opportunity to make an opening statement to the jury. The opening statement is an opportunity for you to tell the jury, if you wish, what you think the facts of the case will be as shown by the evidence. After is not evidence itself. If you don't take the stand, what you said in the opening statement is not considered evidence. Now, when we finish that, the state will present its evidence. You will have the chance to question any jurors that the state any witnesses that the state calls. When the state has finished presenting its evidence, you will have the decision on whether or not you want to testify or offer any evidence. If you choose to testify, then you will be subject to cross-examination from the state's attorney, and if you say anything harmful against to your case, it will be used against you. If you choose not to testify, that will not result in any inference of guilt. However, the jury would not have the benefit of your side of what happened unless you were able to bring it out through another witness. After you have either chosen not to introduce any evidence or have introduced your evidence, then I will be charging the jury on the law applicable to the case, and then they will decide whether you're guilty or innocent. So we're going to bring up the jury panel. We're going to be behind you, so you probably want to switch your chair around to the other side of the table and get the jury.
I have not yet received a list of the state's witness list that I requested earlier.
What?
I have not yet received the state's witness list that I requested from the prosecutor earlier. had our job.
Yeah.
And just a statement for the record, that the witness, that the defendant has been willfully ignoring the instruction of the court and has not pursued with any diligence the process of getting an attorney or asking for an attorney, and thus has impliedly waived the right to an attorney at this trial.
Your Honor, before we go into issue, I think Ms. Williams wanted to put the offer on the record. Do you want us to do that after we took the jury?
Well, let me be clear, I take it you don't want to sign a not guilty plea on the accusation.
Well, I actually have an objection to this on the record. I've not willfully, refused to retain counsel. I would like that opportunity, actually.
But I've made a finding that you have, all those for that.
Sir, how can we proceed with trial when the issue of jurisdiction still has not been satisfied or resolved?
All right, your objections are. Before we begin the selection of the jury, we need to administer an oath to all of you for which your answer should be I do. Please raise your right hand. You solemnly swear or affirm that you shall give true answers to all questions as may be asked by the courts of court's authority, including all questions asked by the parties or their attorneys concerning your qualifications as jurors in the case of the State versus Tanner David Jones. Now, the defendant is seated here. Does anybody recognize the defendant? Is anybody related to the defendant? Any of you recognize the state's attorneys, the other? Anybody personally acquainted with any of the employees of the Solicitor General's office here in the cab? Or with the Solicitor General Don Scribner? All right. Eyes. Have any of you at this stage formed or expressed any opinion with regard to the guilt or innocence of the accused? If you have, please raise your hand. I said, have any of you formed any opinion as to the guilt or innocence of the accused? If you have, please raise your paddles. All right. Have you any prejudice or bias resting on your mind, either for or against the accused? If you do, raise your hand. I need your paddles. Okay. Now, the next question, you should raise your paddles if your answer is no. Is your mind perfectly impartial between the state and the accused? If not, raise your paddle. All right. We are now ready for general questions to the entire panel. The way things are going to work with respect to the mass, if you are asked a specific question, if you need to lower your mask to be heard, people whose turn it is to speak can take off or lower their mask so they can be heard better. The rest of the time, we should keep mess on. Since I'm more or less in a constant talking situation, I do not have my mask, I am vaccinated, and have had my booster shot. All right, state can proceed with general questions.
Good morning, ladies and gentlemen. My name is Glenette Williams. I'm a prosecutor with the Dekalb County Solicitor General's Office, sometimes referred to as an assistant solicitor general. Thank you for being here today. I'm going to ask you some questions to see if you're going to be on the panel today. Please answer as strictly as possible. I do appreciate your time. This is my colleague and trial partner, Ms. Shelton, and she'll introduce herself.
I'm Assistant Solicitor Courtney Shelton.
Okay. So if the question I ask applies to you, please do raise your paddle, and we will take it from there. Is there anyone here who has any training or experience, that is law enforcement related? Okay. So today you're going to be hearing from the defendant in this case, Mr. Jones. And so it's important for you to be able to weigh what you have. Will any of you have any difficulty judging his credibility? And this is not just in relation to Mr. Jones, but any other witnesses, such as a law enforcement officer or someone else who may have been involved in the accident. Okay. And I, Judge did point this out before, but just for you to feel more comfortable, I'm fully vaccinated. I don't care either which way. People have choice, but just to let you know, my trial partner is as well, and just so that my voice can enunciate to you. Is there anyone here who does not have a driver's license? Okay. Is there anyone here who believes that you cannot sit in judgment of someone else? So you'll find it hard to make a verdict of guilty or not guilty because you don't believe in judging on a legal basis. Thank you. Has anyone here ever gotten a citation? Oh.
Anybody here not have a okay, 11 hasn't and 4 hasn't.
Okay. I think we all do that line, this is expected. For those of you who did get the citation, so juror number 4, did you go ahead?
No, he said.
So, one moment, I'll come back to
Only 11 and
that.
4 did.
Okay. Okay, my apologies. For those of you who did get a citation, did you pay that ticket? Okay, so I'm gonna do the reverse again. Is there anyone who got the citation and did not pay the ticket? Oh, thank you.
In other words, she's asking if anyone went to court to contest the citation. You have raised your power.
You as well? Okay.
I have another concept.
Thank you. I guess it was uneventful for you all. For those of you who did receive a citation, did any of you ask for a jury trial? Okay. So this is a bit of a technical one in terms of law, in that traffic citations are considered strict liability. So for example, if you are, if you speeding, so say you're speeding above the speed limit, even though you may not realize that you're speeding over the speed limit, because it's strict liability, you still guilty of that offense. Does anyone?
And don't get into discussing the
Okay.
law with the jurors. We'll deal with discussing the law and jury instructions.
Thank you, Your Honor. So I'll skip that question. Is everybody somewhat familiar with driving in Dekalb? Because I guess you live in Dekalb, right? So, is there anyone who is not familiar with driving in Dekalb? No? Okay, so this accident happened around 285. Is there anyone here who's not familiar with driving on 285? Okay, is there anyone who's not familiar with the Buford Highway area? Okay. Is there anyone here who's familiar as to how busy Buford Highway can get? Okay. Has anyone here ever broken the law? And I know that's a tricky one for most of us.
I think I'm not gonna allow that question, I don't think it's.
Okay. Does everyone believe, is there anyone who, does not believe that the defendant has a constitutional right to a jury trial? Okay. Is there anyone who believes that it is unfair for us as a prosecution in the state to move forward with a trial when someone is representing themselves and not represented by an attorney? Thank you. Will you hold it against the state proceeding with trial of Mr. Jones as he's unrepresented?
Can I ask a clarifying question?
Okay.
Because it's gonna impact my answer to that. If it was his choice, or did he have an option of an attorney?
If he did have an option, will you hold us, will you hold it against us that he's not represented? Oh, thank you. And,
I was 16.
okay, thank you.
I just wanted to make sure he had the option.
Yes, I totally understand that. One moment, please. and gentlemen, that's all I have for now. Thank you so much for your time and participation.
Ms. Jones, do you have any questions for the panel?
Yeah. Is there anyone here who has been given a citation and because of an accident and paid for that accident via insurance or out of pocket? And is there anyone here who paid for that whatever damage and was still given a citation by a third party to pay? Is there anyone here who's been wrongfully convicted of a crime? Or wrongfully charged for the crime? All right, let's go.
Judge, can I proceed with more brief general questions?
What?
Can I read it?
No, I'll go on to individual questions now.
Okay, thank you.
All right, when your name is called, please stand up where you are and, well, when your number is called, stand up, tell us your name, and tell us a little bit about what you do in your principal occupation. Your job, you're a student, you're a homemaker, you have your own business. Tell us just a little bit about what you're doing. All right.
Juror number one, can you stand and state your name?
Hi, my name is Margaret Gilberheimis. My occupation is insurance underwriting.
All right, any questions from the state?
No, Your Honor.
All right, any questions from Mr. Jones?
No, sir.
Did you say no?
No, sir. No.
Okay, juror number two, can you stand and state your name? Sarah Parks.
What do you do?
Manager for Uniform Company.
I think most of them don't need to pull your mask down for a security purpose.
Manager for a uniform company.
Yeah, the other thing you could do is you could come up to the mic and speak.
Can you hear me?
I can hear you, yes. Any questions from the state?
No, Your Honor.
Any questions from the defendant?
Oh, yeah. Are you familiar with King Green Lawn Care? Are you familiar with King Green Lawn Care?
Objection, Your Honor, relevance.
Valid question. Are you familiar with him?
King Green Lawn Care.
King Green?
King.
Yes. No? Okay.
Juror number three, can you stand and state your name and occupation?
I'm here now with the lady, Cherie Coleman, work for Walmart, Cincinnati at Walmart.
I didn't hear your name.
Cherie Coleman.
Okay. Any questions from the state?
No, Your Honor.
Any questions from the chair?
Yes, sir.
Juror number 4, can you stand and state your name and occupation?
My name is Stone Dean, and I basically coordinate the inventory department for Audi Atlanta.
All right. Any questions from the state?
Yes, in relation to, you mentioned something about a citation, you have lifted your panel.
You never got a traffic
You
ticket?
have never gotten a traffic ticket.
Congratulations.
That's all. Thank you.
Any questions from Mr. Jones?
Yes, sir.
Juror number 5, can you stand and state your name and occupation?
My name is Cassandra Palma. I'm a physical therapist at Northside Hospital.
Any questions from the
Can you
state?
continue to stand?
You mentioned earlier on that you may have gotten, you may have gone to trial, you don't recall with the ticket. Or you may have, I think it was annul or something.
Yes.
Okay. And I'm pretty conscious of our current climate. Will you be able to listen to evidence from a law enforcement officer, and once hearing that evidence, make your decision on what has been presented by that officer? Okay, thank you.
Can you continue to stand? Juror
Any questions from the defendant?
No, sir.
Juror number 6, can you stand and state your name and occupation?
My name is James Fuco, and I'm an internal auditor with Truist Financial Corporation.
No questions.
Juror number 7, can you stand and state your name and occupation?
My name is William Quinn. I'm an IT project director for Randstone.
No questions for Mr. Quinn.
No questions.
Juror number 8, can you stand and state your name and occupation?
Yes, my name is Claudia Montero Flores. I work for Transportation Security Administration.
No questions for Ms. Flores.
Is the Transportation Security Administration a form of law enforcement at all? No? Okay.
Thank you. Juror number 9, can you stand and state your name and occupation?
I'm Melanie Porter. I'm retired. I was a director of human resources for a large corporation.
No questions for Ms. Porter. Thank you, Ms. Porter.
No question.
Juror number 10, can you stand and state your name and occupation?
My name is Judy Dell, and I work at UPS. I'm a clerk.
Continue to stand.
No questions for Ms. Young.
No questions.
Juror number 11, can you stand and state your name and occupation?
My name is Lauren Burke, and I'm an emergency room nurse.
And Ms. Burke, you've never had a ticket either?
Correct, yes, ma'am. You might have.
Thank you.
In the whole history of you driving, how many hours out of the day would you say that you drive?
To and from work every day.
That's it?
I mean,
And,
I don't know how to put an exact number on it, but
Okay.
I drive daily.
all right. That's it.
Thank you. Juror number 12, can you stand and state your name and occupation?
Fawn Dalton, and Director of Finance for a large baby good company.
Hello, Ms. Dalton. You mentioned that you couldn't remember if you had contested the citation. I guess it's sometime way back.
Yeah, so I'm pretty sure I put no contest or something, or no low, or whatever at some point.
Okay. And do you believe that you can listen to testimony from law enforcement? And based on the testimony, do you believe whether or not that law enforcement officer is presenting the evidence as he saw it on the day?
Yeah.
Do you have any distrust for testimony of law enforcement?
No.
Thank you.
All right. Any questions, Mr. Johnson?
Yes. When you pled NOLO, were you required to go to court for that citation?
Yes.
You were?
Well, you have to go to court in order to plead. No. For no contest. You have to be present.
Well, did you not have the option to just go ahead and pay the citation?
No, you can't pay it.
Okay. And so what was the reason that you went to court?
To avoid points on my record.
Okay. That's it.
All right. As to the first 12 jurors, will either side be making a motion to strike anybody for cause or bias?
No, Your Honor.
How about you, Mr. Johnson?
No, sir.
We will take about a 5-minute break, let people decide what strikes they want to exercise, and if you want to just walk out in the hall and stretch your legs, or you want to go to the restroom, this would be a good opportunity to do that. And then we'll want you back in the courtroom in about 5 minutes.
All right.
Go ahead and go over with Timothy and how the strikes happen.
Okay, I will.
Mr. Judge, you use the restroom
I do need to be excused for 5 minutes.
Let her know when she comes.
Okay.
I'm doing pretty good. Hey, I did, find out the answer to that question that you asked me on yesterday. All right, I'm gonna come back.
I need
And I'm gonna
to.
explain to you how to strike, okay?
I also need to be excused for about a couple minutes. Is that fine?
Let me ask Judge.
Okay.
Okay.
All right. If your name is called, please step into the jury box. Timothy Ray Parks, Cassandra Rose Palma, James Joseph Duoka, William Thomas Quinn, Claudia Montero Flores, Judy Young. The rest of you are excused and report back to the jury assembly room. I believe they will send you home at that time.
Mr. Joe, you swapped it around.
You probably want to switch around to the other side of the table.
I'm gonna take this, take this.
Ma'am?
Will and truly file a form upon this attestation between the state of Georgia and Tanner David Jones, who is charged with following too closely, and a true verdict give according to the evidence. So help you God?
All right, ladies and gentlemen, you have been sworn in and paneled to try the case of the state of Georgia versus Tanner David Jones. The defendant has been accused by the solicitor in an accusation which reads as follows. The State of Georgia County of Dekalb and the State Court of said county, count one, on behalf of the citizens of the state of Georgia. The undersigned prosecutor, as prosecuting attorney for the county and state aforesaid, does charge and accuse Tanner David Jones with the offense of following too closely for the said accused on or about the 16th day of September 2020. Did follow more closely than was reasonable and prudent while approaching a vehicle from behind that was driven by another in violation of Official Code Georgia 40-6-49. The above offenses having occurred in DeKalb County, Georgia, contrary to the laws of the state, the good order, peace, and dignity thereof. To this accusation, the defendant has elected not to plead, and this has the effect of a plea of not guilty, and therefore it operates to deny each and every allegation in the accusation. This forms the issue that you have been selected, sworn, and impaneled to try. Before we begin the trial, I'm going to give you a few preliminary instructions on the procedure we'll be following and some basic principles of criminal law. The defendant is charged in the accusation with a what? I have it in front of me on the screen, so I'm sorry, the defendant is charged in the accusation with a crime that is a violation of a law of the state of Georgia. I want to emphasize to you that the accusation and the plea of guilt, of not guilty, or the lack of the plea, are the procedures by which this criminal charge is brought before you for decision. The charge is not evidence of guilt, and you should not consider it as evidence or implication of guilt of any crime whatsoever. The defendant is presumed to be innocent until he is proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his favor, and this presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the crime charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the accusation and every essential element of the crime charged beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It's the doubt of a fair-minded, impartial juror honestly seeking the truth. It is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, a conflict in the evidence, or any combination of these. There is no burden of proof on the defendant whatsoever, and the burden never shifts to the defendant to prove innocence. If, after giving consideration to all the facts and circumstances of the case, your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you should acquit the defendant. But if no doubt exists in your minds about the guilt of the accused, then you are authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Now, in our system, it is my duty as a trial judge to determine the law that applies to this case and to instruct you, the jury, on the specific rules of law that you must apply to the facts in arriving at the verdict. I'm giving some instructions now. I'll give further instructions after the evidence has been presented and each side has made their closing argument. During the trial, I may be called upon to rule on motions or objections to evidence. Nothing I say in making these rulings or at any time during the trial is evidence and should not be considered as an indication that I have any leaning in this case whatsoever. My only interest is to see that it's tried fairly according to the laws and Constitution of the state of Georgia and the Constitution of the United States. It may be that on certain objections, I may need to consider them outside your presence, in which case I'll ask you to go into the jury room. The procedure is generally as follows. Each side will have an opportunity to make an opening statement. The opening statement is not evidence, but it usually involves a preview or outline of what each side expects the evidence will be. Following the opening statements, evidence will be presented, which can be in the form of testimony given by witnesses or physical evidence that will be labeled with an exhibit number for identification. After the presentation of all the evidence, each side has the opportunity to make a closing argument. At that time, each side may suggest what laws are applicable and how they should be considered in light of the evidence and point out to you the parts of the evidence they think are favorable to their position. The goal of the closing argument is to persuade you to decide the case in their favor. Following the closing argument, I will give you more specific instructions on the law that applies to the case and then ask you to retire to the jury room and deliberate and reach a verdict. It is your duty to determine the facts of the case and then to apply the law I give you in the charge to those facts. I will instruct you on the laws that apply to this case, but you alone determine the facts from the evidence. And so at the end of the case, I can't answer any questions about the evidence. Sometimes jurors ask me questions about the evidence. That's not my role. Evidence consists of testimony and exhibits, as I said. You will hear testimony under oath from the witness stand, and exhibits are those documents, photos, or other physical items that are admitted into evidence. The object of the trial is to discover the truth. During the trial, the admission of evidence will be governed by the rules of evidence. Those rules were drafted with one prominent purpose in mind, and that purpose is the discovery of the truth. Consequently, the rules of evidence seek to assure that only reliable types of evidence are admitted for your consideration. If an objection is made, I will admit or exclude the evidence according to those rules. If I overrule an objection, that means you are allowed to consider the evidence being offered. On the other hand, if I sustain an objection, this means you may not consider the evidence being offered. You should consider only that testimony and only those exhibits that are admitted, and you should draw no inference and make no assumption about evidence objected to if the objection was sustained. You determine credibility and believability of witnesses. It is for you to determine which witness or witnesses you believe and which witness or witnesses you don't believe, if there are any whom you do not believe. In determining credibility and believability, you can consider all the facts and circumstances of the case, the manner in which the witnesses testified, where applicable, their intelligence, their interest or lack of interest in the case, their means and opportunity for knowing what they're testifying about, the nature of the facts they testify about, including the inherent probability or improbability of their testimony, and of the occurrences about which they testify. You may consider personal credibility insofar as may appear to you from the trial of the case. It is your duty to believe the witnesses whom you think are most believable. It is for you alone to determine what testimony you believe and what testimony you don't believe. It's important that you pay close attention to the evidence during trial. If at any time you are unable to hear or see any evidence being presented, or if you are suffering from discomfort that diverts your attention, please feel free to inform me by raising your hand, and I will do what I can to assure that you're able to hear and see the evidence being presented and give it your undivided attention. If you're in need of a recess at any time, please raise your hand and I will recognize you. It's important that you view the evidence with an open mind at all times and reach no final conclusion until the trial is over. Don't jump to conclusions before all the evidence is presented. During the trial, it would be improper for you to discuss this case with anyone or to allow anyone to discuss this case with you or in your presence or hearing. This includes even discussions among yourselves in the jury room or elsewhere before actual deliberations begin. And that sounds like a peculiar rule. One of the reasons is if you start expressing opinions about the case, it may be hard for you to keep an open mind. So we don't want you talking about the case until all the evidence is presented. And we encourage the parties and the attorneys to keep their distance from you during the trial, so there's no possibility of any improper communications taking place. You can take notes if you want to, you're not required to. Some of you from your experience in college or high school or business will find it easier to follow things and remember things by taking notes. For other people, that might mean a distraction. Don't feel like you need to take notes. Notes are for your use only and not to be shared with anyone until deliberation. And they're not evidence, they're only memory aids. They don't take recollection. They don't take precedence over recollection. It's the duty of each juror to recall the evidence, and while you can consider another juror's notes to refresh your memory, you rely on your own recollection of the proceedings. They're not entitled to greater weight than the recollection or impression of each juror as what the evidence may have been. You decide the case for yourself solely on the testimony you hear from the witness stand and exhibits admitted to evidence. Okay, and the other thing is, some of you probably have cell phones. Don't use your cell phone to look up anything about this case. While the case is pending, don't feel like you should be sending out any messages about what you're going through. It's all over. You can tell people whatever you want to about the case. But during the trial, you're not to communicate either electronically or in person with people about the case. And don't look up anything about the parties, about the facts, about the law on your mobile device. All right, with that, we are done with my preliminary. instructions, and now each side has the opportunity if they wish to make a brief opening statement about the case. The state goes first.
Ladies and gentlemen, good morning again. As I previously said, my name is Janet Williams, and I'm an ESG with the Dekalb County Solicitor General's office. Now, I don't want you to be distracted by my accent, so full disclosure, I am British Caribbean, so you will have some bit of a tone, so that you're not distracted by trying to figure out where I'm from when I'm speaking. So, what will be presented today? So state will present to you that on or about the 16th of September, Mr. Jones was traveling along Buford Highway. At that time, while he was traveling along Buford Highway, traffic ahead of him came to a stop. When the traffic came to a stop, Mr. Jones' vehicle then hit another vehicle from the rear. So we refer to that as being too close, following too closely. So his vehicle hit the other person who was stopped directly in front of him, Ms. Coutwan. You will hear from Ms. Coutwan today that she was driving, the vehicle had come to a stop, and that she felt an impact. You'll also hear from the officer that came to the scene as a result of the call being made for the accident. Once again, I thank you for coming out today. I know we're in the midst of the pandemic, and it's not one of the. It's just a following to go through. It's not as exciting a case as some cases. But it's still important because Mr. Jones does have the right to a jury trial. And we live in a place where we have our constitutional rights whereby we can challenge a charge that is levied against us. And so you being here today gives him that opportunity and gives us the opportunity as a state as well to allow him to present his case, and then you very able people will make a determination as to how you see fit. I'm a pretty straight shooter, so I'm just going to tell you as it is, and then I'm going to leave it to you to make the decision. We all come in here being ourselves, in that we all come in with some sort of experiences. We don't come in as a blank slate. And so that's why it's good to have a good cross-section of you, because I'm hoping that you're going to use your life skills and your life experiences and apply it to the case. And once you apply it to the case, come up with a verdict which you think is fair and just, provided the evidence that we will present. Ladies and gentlemen, I thank you.
All right, Ms. Jones, do you want to make a motion?
Yes. Good morning, everybody. I would like to urge you to listen to the actual facts of the case and realize what the state just said. They have no actual firsthand knowledge of the events that occurred that day. Just sitting there, I already pointed out 3 discrepancies in what she said. I'm not going to point those out right now, but hopefully this will get along. I know everybody has jobs to go to, and I'm the same way. I'm missing out on work too. So please listen to what the law says and have some discernment on whether that law actually applies to the facts of the case. and that's it.
All right, this time we're gonna break for lunch, and I'll ask you to return. Let's not get that. It's 1 o'clock. How do we go about it?
Yes, you can look at those here, because we're gonna lock up the courtroom will be locked up, so if anything you need to read, you need, but you can leave your name.
Go ahead.
Good afternoon, Ms. Coutwan. Thank you for being here today. Ms. Coutwan, can you please spell your name for the record?
Celia Coutwan, Celia, Coutwan, K-O-U-T as Tom, O-U-A-N as Nancy.
Thank you, ma'am. Ms. Coutwan, and I'm really bad at pronouncing your name, as you know by now, and I'm trying my best. I'm on or about the 16th of September of last year. Were you involved in an accident?
Yes, I was.
Okay, and where was the location of that accident?
It was before I took the highway on Buford, the highway on Buford Highway, and it was about a block from the Buford Highway Farmers Market.
Okay, and is that in Dekalb County?
Yes, it is.
Okay, and the person who you had the accident with, do you see that person in the courtroom today?
Yes.
Can you please describe a piece of clothing he's wearing?
Blue, and jeans.
Okay, thank you. Your Honor, if the record could please indicate that the witness has identified the defendant, Mr. Jones. Can you please tell me what happened on that day?
Okay, so I was about to take the highway to go back home, and before turning into the highway, there was a red light, so I stopped for about a minute or two before I heard the heat from the back. Heard the heat. The car hit from the back.
And when you, oh sorry. And did you feel some sort of impact when you heard that?
Yes, I did.
Okay, thank you. So once you felt the impact and you heard that sound, what happened next?
So I got out of the car, parked it, put it in park position, and I got out of the car, and I was observing the damages to the back, the trunk part of it, and the guy that hit me came next to me, and he apologized for hitting me, and I went back into my car, I took my phone and started to call my insurance.
Okay, and then did the police arrive shortly thereafter?
Yes, they did.
Okay, and when the officer arrived at the scene, did you speak with the officer?
Yes, briefly, yes, if I was okay, if nothing happened to me.
Okay, and did the officer also speak with the defendant, Mr. Jones?
Yes, I believe so, yeah.
Okay, and did you receive a citation for this accident?
No.
Okay, can you describe the location where the accident happened?
So there were 3 lines on my right side, and then I was on the very left line, the only one that was going to the highway.
Your Honor, can state would like permission to show a depiction of the area where the accident happened on screen, if that's okay.
Can you, show it on, the computer to the defendant first?
Yes, Your Honor.
Any objection?
It was actually further back than that.
Well, that's a factual dispute, we'll have to, that needs to be upheld in the testimony.
Your Honor, we'll back this up. I'll proceed in the meantime.
Okay. Oh,
And while we wait on that, because you did mention, can you tell me if any landmark that was where the accident happened?
I remember it was under a bridge.
Okay. Your Honor, permission to show the defendant the updated photo?
all right.
Thank you, Your Honor. Ms. Coutwan, is that a fair depiction of where the accident happened?
Yes.
Would you say that that's an accurate depiction of where the accident happened?
It's also behind you. You can locate the place.
Your Honor, can state please publish the photo as being a depiction of the area where the incident happened, the accident happened? And Ms. Coutan, I know this accident has been some time now. Could you describe where the damage to your vehicle was?
It was the trunk on a side of it, and then there was a little bit of damages to the light.
Okay, so the back lights.
Yeah, it was
Okay, and I would imagine that you took photos of that on the day.
I did, but I couldn't find it on my phone.
And is that because it's been such a long time ago?
Yes, I think so.
I apologize for the delay in having the case to court. One moment, please.
All right.
Your Honor, State is finished with this witness for now.
Yes.
Can you ask the court from where you are or from the podium?
Hey, how you doing? Do you remember the type of vehicle that I was in when the accident occurred?
I remember it was a white little truck that sometimes you put the trees, when you cut the trees, you put the trees inside.
Kind of like a landscaping sort of thing?
Yes.
Okay. How would you describe the severity of the damage to your vehicle?
I'll say on a scale of 1 to 10, I'll say 6.
6? Okay. Did you receive any medical attention that day?
No.
Do you feel any effects now because of the accident that occurred that day?
Objection, Your Honor, relevance.
question?
No.
All right. And did insurance take care of the damage to your vehicle?
Yes, it did.
Okay. Do you recall which insurance company it was?
Objection, Your Honor, relevance.
Yeah, I'm also saying that it's not relevant to what we're here for.
Did you request for the officer to give me a citation?
If I requested it?
Yeah.
No.
Okay. And are you satisfied with the outcome of the whole situation? Like your car is completely fixed and.
Objection, Your Honor, relevance.
Also saying that could be something. All right, let's send the jury out for a moment. You think I'm going to jury room? All right, so that's not relevant to the guilt or innocence phase, but it could be relevant to sentencing, so I'll let her answer the question. Or you can ask it again.
Were you satisfied with the outcome of the situation? Like the repairs on your car, were they satisfactory to you?
Not really, because I had to get rid of the car.
You had to get rid of the car? Well, and why was that?
Because it didn't look good.
It didn't look good? Okay. And was that because of the shop that you took it to, or what your insurance or my insurance recommended? I'm sorry?
Objection, Your Honor.
I'm not letting the jury hear this. This could conceivably be relevant later on in terms of whether there's going to be restitution or not. So I'm going to let him ask some questions now. But outside the presence of the jury, we're not going to do this in front of the jury.
Thank you, Judge.
When I got out of the car and came up to your car, did I ask you if you were okay?
Mm-hmm.
You mentioned earlier that I apologized to you. Did you find that apology to be sincere?
Yeah.
No further questions.
Do you have any other questions?
No further questions.
You can step down and wait outside. You can ask the other witness to come in, I guess, right?
Your Honor, State Falls Officer Warren Gregory.
Objection, Your Honor. Does the witness have personal knowledge that this specific code applies to me?
Well, you can object to individual questions. Certainly anything that was said by you to him at the scene would be admissible as an admission. So he's bound to have some testimony that's admissible.
thank you for being here today and for your patience. I know it's been late. Officer Gregory, where are you currently employed?
I'm currently employed with the City of Doraville Police Department located in Doraville, Georgia.
Okay. And how long have you been employed with the City of Doraville?
With the City of Doraville, it's been a little over 5 years.
Okay, awesome. And are you course certified and are you a course certified and approved law enforcement officer for Doraville?
Yes, ma'am.
Thank you. And do your duties include enforcing laws?
Yes, ma'am.
Does that include enforcing traffic laws?
Yes, ma'am, it does.
Okay. Approximately how often do you respond to traffic accidents?
It depends on the day. They vary. It could be anywhere from 3 to about 5 vehicle accidents a day.
Wow, I didn't realize it was that many.
Yes, ma'am.
And how many accidents then will you say, traffic accidents, you have investigated over the course of your career?
I would say it'd be a few hundred. I don't know the exact number.
Okay, thank you.
Yes, ma'am.
When you respond to an accident scene, what do you typically do first?
When I respond to a vehicle accident, I try to make contact with both parties at the scene. The first thing that I do is determine if anyone is hurt or injured, if anyone needs emergency medical services. And then after that, I get the statements of both drivers to determine how the vehicle accident occurred.
So, do you speak with these drivers separately or together?
I try to speak with them together, and if I notice any conflicting stories or statements, then I'll go and I'll speak to one driver separately and then speak to the other driver separately.
Okay. And if that's the case, I guess you determine who you'll speak with first, depending on what you've heard from them speaking with them together?
There's not really any determination, but if I notice that there's some inconsistencies, then I may speak to a particular driver first before speaking to the other driver.
Okay. And in investigating traffic accidents, how often will you say that you actually see the accident happening versus being called to the scene of the accident?
Very, very slim.
Okay. And does that mean that you cannot make a determination based on the evidence that you see at the time?
I'm sorry, can you ask that?
Does that mean that you cannot then investigate and make a determination, at least cursory, based on the evidence that you see when you arrive at the scene?
Yes.
I would. So based on, even though you're not present, are you able to look at the evidence on scene and decide who the ticket should be issued to?
No, it's also in relation to the damages on the vehicle, is also according to their testimonial evidence that they provide to me at the scene.
Awesome. So what you're telling me is the totality of the circumstances?
Absolutely.
Okay, so that involves maybe, as you said, speaking with the parties on scene, looking at the vehicle, looking at the area as well, in making your determination?
Yes, ma'am.
Awesome. And do you always issue a citation?
No, each accident is different. Sometimes there are conflicting statements with the damages, and unfortunately I'm not able to issue citations for those offenses.
Okay. So if you're not able to determine based on the statements and the evidence that you see, you don't issue a citation, is that what you're saying?
Yes, ma'am.
Okay. How do you sort of spoke about it just briefly a while ago. How do you go about determining who you believe is telling the truth?
Just the testimonies, what they tell me, their view, their perspective on how the accident happened, and also the damages on both cars, and also the corresponding Georgia laws with, the uniform rules of the road.
Thank you, Officer Gregory.
Yes, ma'am.
Officer Gregory, on or about the 16th of September 2020, who were you employed by?
The City of Dorville Police Department.
Okay, and were you on duty in uniform in a marked police vehicle?
Yes, ma'am, I was.
And I know sometime, since then, do you remember by any chance what the traffic conditions were on that day?
I'm not really sure. Can you, refresh me on what time of day was on that, accident report, please?
Yes, let me go back to it. So it states it was around 11:52 a.m.
Normally around that time of the day, there's still moderate traffic conditions. I'm not sure the exact conditions that day, due to it being over a year ago.
I understand. And did you review your report from that day in preparation for trial today?
Briefly, not 100%.
Okay. And, do you remember, attending to an accident on Buford Highway, just under the bridge, on or about the 16th of September 2020?
It just was listed on the report.
Okay.
So it is, I've worked so many, it's
I understand.
kinda hard to remember.
But you did mention that you refreshed your memory, from the report before today.
Yes.
Okay. Can you give me a brief description of the area that you were called to?
Sure. So it was on, Buford Highway northbound underneath, Interstate I-285. That particular lane of roadway, there's a left turn lane and there's 3 lanes that travel straight underneath the bridge.
And, the previous witness, identified, this location. Does this location look familiar to you, sir?
Yes, ma'am.
Okay. And will you say that that's the location that appears to you to be where the accident happened?
Yes, ma'am.
Okay, Judge, we published it already, so, I don't believe we need to again. Can you please describe the scene when you arrived?
I can't recall. I can't recall. I would have to review my video, my bike cam.
Okay. Just stepping back for a moment, when I showed you the video just a while ago, you mentioned that it was about that vicinity. Is that in Dekalb County?
Yes, it is.
Okay, thank you. And I do appreciate, you being straightforward with me when you do remember and not remember something. That helps me. So, once you got to the scene of this accident, did you speak with Mr. Jones?
Yes, I did.
Defendant?
Yes, ma'am.
Okay, and did you speak with Ms. Kutan?
Yes, ma'am.
Okay. And at that time, did you ask for identification of both parties?
Yes, on all vehicle accidents, I asked for identification as well as insurance information.
Okay. And when you asked for identification, did you, receive any identification that matched, the appearance? Did the appearance of the individuals match the photos?
Yes,
on the
ma'am.
ID?
Yes.
Okay. And I'll come back to that in just a bit. So you stopped well, they were already stopped because they had an accident. When you spoke with the defendant, Mr. Jones, did he say anything about how the accident happened?
I don't remember exactly, word for word what he said. It's all listed on my report, but on that scene, I believe that he mentioned that he was traveling behind that vehicle in the same lane. I can't recall exactly how the accident happened or exactly how he worded it happened.
Okay, and I respect that. And did you speak with the victim, the other party to the accident?
Yes, ma'am.
Okay, and did she say anything about how the accident happened?
Just that she was traveling in the same lane as well, and that she felt a bump from the rear of her vehicle.
Okay. So usually when you go to the scene of an accident and there's damage to a vehicle, when the damage is in the center back of the vehicle, what do you normally deem that as?
Usually that's indicative of usually rear end collision. That's usually indicative of following too closely when the vehicle that's traveling behind another party's vehicle is traveling too close to where they can't reasonably and safely adjust to that other vehicle that they're traveling behind. So if they're traveling behind that vehicle, if they can't safely come to a break or stop, that's generally falls under following too closely.
So you're saying then that as we drive on the streets, we are to keep a safe distance from the vehicle ahead of us?
Yes.
Okay, and that is as prescribed by law?
Yes, under following too closely.
Thank you.
Yes, ma'am.
So we spoke about the totality of the circumstances earlier on. So I'm gonna ask you a pretty lengthy question because it has several pieces to it. So based on your experience, which is several years, your formal training, statements which were made by the defendant and the victim, and what you observed on the scene on that day, did you make a determination as to who, if anyone, was at fault for this accident?
Yes, I did.
And who did you determine was at fault for the accident?
Mr. Jones, who's sitting over to my left, wearing a blue shirt, blue jeans, and white shoes.
Your Honor, if the record can please reflect that the witness has identified Mr. Jones, the defendant in this case. Your Honor, that is all the questions that State has for this witness at this time.
Mr. Jones, you may
Do you recall the type of vehicle that I was driving in that day?
It's listed on the accident report. I believe that it was a Isuzu box or work truck, possibly a flatbed truck.
Do you recall?
It's listed on the accident report.
Do you recall if there was any equipment loaded on the back of it?
No, I do not.
Okay. When you say traveling, when one vehicle is traveling behind another, what exactly? How would you define that word traveling?
A vehicle that's operating on the highway.
Okay. Would it be safe to say that being in motion would be a part of that definition?
Yeah, the vehicle has to be in motion to be traveling. So,
okay,
yes.
Thank you. And were you forced to be here today?
No, I was requested to be here.
By who?
It is by the judge. Yes.
Okay. And were you prepped for your testimony before today, or earlier today, prior to this trial?
I was issued a subpoena along with the report from the incident.
Did you speak to the state prior to this trial
In reference
to the trial?
just about where to be here and things of that nature, but not pertaining to this case.
Not pertaining to this case. Okay. And are you an honest man?
I'm sorry?
Are you an honest man?
Objection, Your Honor. The witness says credibility has not been put on question here, so he shouldn't be able to ask a question.
I'm just trying to figure. I'm just trying to determine the character of the witness.
I'll allow the question. You can answer the question.
We're all, as police officers, are required under the official oath that we take for office to be honest.
Okay.
And to tell the truth.
All right. So people should take you at your word, correct?
But we're required to be honest.
And do you have any firsthand knowledge that I violated the code of following too closely?
As I stated earlier, the way that I investigate traffic accidents is that I speak to both parties based off the statements on both parties and also the physical evidence of the vehicles. If I notice anything that violates state law, then that's generally addressed.
Okay. And what about the events that occurred led you to make a legal determination that this was the statute that I violated?
Based off of my knowledge and experience and training with the official code of Georgia annotated.
Okay, that didn't answer the question. What about the events that occurred that day?
Based off of my knowledge,
Based off what
experience of Georgia state law.
Based off what the statute says.
Yes, sir.
You made a legal determination that I was in violation of the code. And what about that specific code made you make that legal determination?
Based off the statement that you provided to me that day, the statement from the other party that was involved, and also the damages on both vehicles.
Okay, I'm being very specific to the code. The code. There's subsections A, B, C, and D. Which one would you say that I was in violation of? You've dealt with hundreds of cases like this, so I'm sure you should be pretty familiar with the code. What in the code made you make a legal determination that I was in violation of the code? What part of the code?
Your Honor, I'm asked and answered. The officer is not an attorney. State did receive this case and did then accuse the case.
Well, given the fact that you asked the officers similar questions from the other side, I think it gets a certain amount of leeway to get answers on this, but I would agree that which subsection it is not an appropriate question. What did you think he was in violation of? What duty was he in violation of?
Yes, sir. Based off the statements that him and the other party provided, I have reason to believe that he was traveling behind the other party's vehicle and didn't travel behind that vehicle safely to where he could have stopped his vehicle in time to avoid the motor vehicle collision.
The record will reflect that the first witness's testimony said that we were at a red light already. So when you say that we were traveling and being in motion.
Objection, Your Honor. Defendant is testifying.
Finish your question. Finish your question.
All right. Just lost train of thought. So are you qualified to make legal determinations, not being a lawyer?
Don't answer that question. That's not an appropriate question.
Around, you stated that the accident happened around, or the state stated that the accident happened around, or you wrote the ticket at 11:52. Was that correct?
Whatever date is listed on that citation, whatever date and time is listed on that citation, that's the date and time that I wrote the citation at.
Okay, and so are you able to tell the court what time the accident occurred?
No, I'm not, because I was not there at the time the accident occurred.
So you did not witness the accident and the nature of it and how it occurred?
No, I responded after the accident occurred.
Okay.
After the accident occurred, that's when you were the other party and contacted 911.
So you determined on your own that the code that you wrote the citation for applied to me?
Based off of your statement, the other statement provided by the other driver and the damage on the vehicle, I believe, and my training and knowledge as a police officer and under Georgia state law, I believe that you violated a law, and that's why you were issued the citation.
And do they train you on the official Georgia code, official code of Georgia annotated? Do they train you on that?
Yes, every police officer in the state of Georgia undergoes criminal procedures, and criminal law is discussed with that along with also traffic law is discussed as well.
Okay, so, and you determined that I violated the code. So are you certain that I violated the code?
Based off of the physical and testimony evidence that day, I was able to determine that you were at fault driver.
And what about my testimony made you make the legal determination that I was in violation of this code?
Based on the fact that you were traveling behind the other vehicle that was the other driver that was involved, and you were unable to stop your car safely to avoid a motor vehicle collision.
Okay, are you aware of any part of the following too closely statute and what it reads?
I'm sorry, I do not understand the question you're asking.
If you had the statute right in front of you right now and everything it says, would you be able to point out exactly what it was in that statute that I violated based on my testimony, the damage to the vehicle?
Under that statute right there, yes, because it defines that.
Okay, so All right, so what you're saying is you're able to make the legal determination if you had the statute right in front of you, but based on the testimony from me and the other driver and the damage to the vehicle, you're not able to tell me exactly which part of the code that I violated.
That's not what I said. What I said is that when I make a determination at that fault driver, I take into account physical evidence, testimonial evidence, and also the Georgia state law. All three of those things are taken into consideration.
Okay, so at this point, you're not able to recall?
It's been asked and answered.
This is a different question, sir. All right. So from what I've gathered, you can make a legal determination at the scene based on testimony from me and the other driver, but you can't remember what the testimonies are. You've dealt with the following too close statute many times in your career, but you can't tell me what part of the code off the top of your head that I violated. And
Your Honor, asked and answered.
no, I'm just making a recollection of everything that's been said.
Objection, Your Honor, the defendant is testifying.
All right,
Yes, sir.
go ahead. State the whole question.
So, all right, so you, just to be clear, you did not witness me violate any code, but you're here to testify that I did violate the code, correct? Yes or no?
Yes.
Okay. And are you an expert in the interpretation and the application of the Constitution and the laws?
No.
So if you're not an expert,
All right.
when you determine I was...
Hold on. Ladies and gentlemen of the jury, as I told you at the beginning of the case, you're supposed to take the instructions on the board. We've had enough questioning about the officers understanding the law. Because the state had asked some questions about that, I allowed you to go into it a certain amount, but it's basically not proper questions. We're supposed to be determining the facts of the case in this testimony.
Okay. In my testimony,
Well, you haven't testified yet. You'll make
No.
a decision on that when the state's done.
I meant at the scene of the accident.
You're talking about, okay. That's not testimony, so why don't you use some other word?
I'm just using the word that.
Statements.
Okay. In my statement that I made at the scene of the accident, do you have any recollection of that statement that I made?
No, the accident was recorded on my body camera as well as my dash camera.
And you did not review any of that before today?
No.
Okay, so all right. So you don't recall any specific facts of this case other than that an accident occurred and I was cited and now we're here.
Objection, Your Honor, the witness has already testified.
No, that's fair cross-examination.
Okay.
Can you address that question, please? Can you ask that question?
I'm sorry, I've got very, very short-term memory loss. Let me take a second to think about exactly how I asked it. So you did not, you have no recollection of any facts of the case other than there was an accident that occurred, I was cited, and here we are today, correct?
What I have on the report is what I witnessed that day.
And has the report been submitted to evidence?
I don't know. I can't answer that question.
Well,
You did testify earlier that the damage was to the rear view.
Yes.
and you also testified earlier that not every accident that occurs in this fashion, not every occurrence, someone receives a citation, correct?
There's times where there are conflicting statements that are provided by both parties that doesn't correspond with the damages to the vehicle. In those cases, I do not issue citations because on those I'm unable to determine that fault party.
And do you recall any conflicting statements between me and the other driver?
No.
But you wouldn't be able to say that with 100% surety because you don't recall our statements, correct?
Testify to what my report has. My report is what I witnessed on that day.
Okay. How are you able to testify to your report if you don't know what your report says?
Because the report is an official state document.
But that report is not here today.
And all of that stuff has been recorded on dash camera and on body camera.
And
You testified earlier that you reviewed your report briefly, but not.
Yes, just the state accident form, I briefly glanced over.
But you didn't study it in depth.
No, sir.
well, I motion the court to dismiss this case based on lack of credibility from the witness.
That's premature. You need to wait until the state's versus case. At that time, you can make such a motion.
Yes, sir. All right, no further questions, sir.
Thank you.
falls within the ordinary course of your duties, the ordinary course of business?
Yes, we're required to investigate motor vehicle accidents along with other incidents that occur in the city limits.
Are you expected to remember by memory the hundreds of cases you investigate per year?
No.
And is it customary for you to, in a case like this where there is trial, refer back to that report?
No.
I'll rephrase.
Okay.
So, if you do have trial and the accident has happened sometime before,
Okay.
before coming to testify, do you review somewhat that report?
Yes.
And you mentioned earlier on that you had somewhat reviewed the report. When you say somewhat reviewed, were you referring to essentially date, time, or were you referring to the lines which you would have written about what your determination was?
Yes. So I reviewed the narrative, what happened, as well as the diagram on the accident report.
And is that essentially the crux of what tells you what happened on that day?
Yes.
Thank you. So when you arrived to the scene, Officer Gregory, was Mr. Jones, the defendant, was his vehicle behind of Ms. Coutan's vehicle?
Yes.
Was there damage to Ms. Coutan's vehicle?
Yes.
Was that damage to the rear of the vehicle?
Yes.
Was that damage to the rear middle of the vehicle?
Yes.
Was Mr. Jones, the defendant, cited?
Yes.
Thank you, Officer Gregory.
Any cross-examination?
Do you recall if there is anything in the code pertaining to motor vehicle accidents?
I'm not going to allow additional questions about the law. The state didn't ask any questions about the law. And fundamentally, that's not an area to ask the witness about.
Okay.
I'm going to ask them about the things that the state asks about or that